Okay, short-term rentals. It's our perennial topic, and there's always a little bit more information I can share. First piece, Chief Rosano and Vice Chair Grifoni at our last meeting this past Monday went over the numbers, and actually Chair Grifoni presented them on a number of noise complaints we had through the first 3 months of this year. And there was actually one verified noise complaint in each month of January, February, and March. Only 3 so far for the first 3 months of the year during basically high season. So it appears, to me anyway, that our noise ordinance is having a good effect, and we're not having the kind of problems we've had in past years. So good news there. Secondly, I had a conversation with the city attorney at the meeting on Monday night, and I wanted to go through with him the state of play legally with regard to our ability to regulate short-term rentals. Councilor Rolla at one point in the meeting pointed out that the way typically zoning laws are understood is if something is not a permitted use in a residential area, then it's a prohibited use, and short-term rentals are not explicitly permitted under our land development code. I asked City Attorney Alan Gabriel about that, and also about his comment back in 2009, which appeared to indicate that he believed that to be the case as well. He explained that there were a number of city officials who had said that that was probably the case, but his advice was, even if that were true, there was no enforcement mechanism in place under our city statutes, and without an enforcement mechanism we had no way to prevent short-term rentals in residential houses. So that was his recommendation, was that the city at that time, 2009, go back and create an enforcement mechanism so that we can, if we want to prohibit short-term rentals, have the process to do it. The city made a recommendation to send that back to the planning board, and nothing ever came back to city council prior to the passage in 2011 of legislation in Tallahassee, the state of Florida, preempting any zoning requirement which prohibited short-term rentals, which was not on the books prior to 2011. Mr. Gabriel gave the opinion that since we had no enforcement mechanism and none had been adopted, there was no consistently enforced rule, and therefore the state law preempted any enforcement against short-term rentals on our island. That has continued to be an issue of contention, and there have been previous discussion about getting an Attorney General opinion on that to see what the Attorney General thinks about Mr. Gabriel's opinion. So I talked to Mr. Gabriel about that, both before the meeting and during the meeting. And he provided me with documentation from the State Attorney General's office where they opine on the process for giving opinions about local ordinances. And that's what this would be an interpretation of, the Marco County ordinance, and whether it effectively prohibited short-term rentals prior to the passage of the 2011 legislation in Tallahassee. What that documentation said is that they don't get into interpreting short-term city ordinances, and if there is a question about city ordinances, they're going to send it back to the city attorney. So if we ask for an opinion, it would just go back to Mr. Gabriel for his opinion, which has already been rendered. So then I asked him, what other rights are available? And if a citizen or a group of citizens still dispute Mr. Gabriel's interpretation of our statute and believe that short-term rentals are prohibited, notwithstanding the state preemption, they can go in for a declaratory judgment action in state court. In fact, that's what the Attorney General recommends in their documentation. So that is an option that our citizens have if they wish to do it. And actually, Mr. Gabriel thought that would be a good way to solve this issue once and for all. So that is his perspective, and I think it might be a good solution if people continue to believe that short-term rentals are not permitted under our land development code. Finally, we talked about the deeds which are in every homeowner's property on Marco Island. Those deeds, all of them, specifically prohibit a trade or business being operated on a property, and also preclude any property from becoming a nuisance to their neighbors. It also provides that any citizen or MICA may bring an action in law and equity in state court to enforce a breach of those provisions and protect their rights against being annoyed or nuisance by neighbors. It also requires that neighbors maintain their trash in an orderly manner. And so there's another opportunity or cause of action for people who find that short-term rentals are very problematic to them. One final point, Ed Isler and a group of citizens have put together a petition to have a rental registration ordinance on the ballot, probably going to be on the ballot this August, and it would require registration by all property owners who intend to use their property for short-term rentals, and a fee, and that is going to come up to the vote of the citizens. That may be another way to put some additional controls on short-term rentals that is permitted under state law. We'll get more updates on that as it comes forward. At any rate, that's the latest update on short-term rentals. I wanted you to understand your legal rights and what the city is governed by in this situation. Thank you.